opposing counsel has told the court. The only Rule 7.1 good faith consultation I've ever had with Ms. McCready was with regard to our or their potential motion to dismiss, in which, again, I said I would drop almost all the claims, but we just wanted books and records. They said no to that. So I said, okay. So they created all of this work when all we wanted was books and records and answers about rent. And I could not get those answers. So instead, they filed a motion to dismiss on all the claims when I offered to take most of them off the table. So they created this work for themselves when I was more than willing to please just give me the books and records so my client can get the books and records, which we believed we were entitled to. And also there were issues with the rent payments, and we didn't want the landlord locking us out and selling the prototype or auctioning it off. So if the court deems fit to turn our motion to strike into a response, I'm okay with that. But there was no meet and confer. Secondly, there's no written notice of my specific conduct, which was I never had an opportunity to cure. I don't know what they think I did that was sanctionable. There have been other firms, of course, they all get a pass apparently. The big boys like, Mr. Carmel, like Gallagher and Kennedy. Well, they're all tight. So it looks like just go after Mr. Powers, the scapegoat, which, I don't understand it. I've been on since fall. I've been trying to make deals with the opposing party this whole time. We wanted the books and records. We wanted answers about rent. We wanted to know about the IP. Our claims are legitimate. And I don't know what I did that's sanctionable based on their motion. I need some numbers because it ain't 800,000. I'm pretty sure of that. I had nothing to do with the receivership hearing, which I believe was legitimate. I did go through the record and I found legitimacy in otherwise I wouldn't have taken on the client, especially under the circumstances where there had been missed rent and we still couldn't get books and records. Thirdly, we believe that it was untimely because it has to be brought under Britt v. Stephan. The Rule 11 must be brought within a reasonable time. They claim that everything that the plaintiffs did violated Rule 11, yet they waited for over 2 years to file the Rule 11. I guess to get me, or are there other attorneys on the hook? I don't know, because I don't know what I did. She didn't specify. They didn't specify, Your Honor. Again, and for the fourth point, I've already touched on it, but the selective targeting, it speaks for itself, quite frankly. This has been a tough case, but there's no question that rent was missed. There's no question we couldn't get books and records. There's no question that the IP expired. And so all I wanted my client to be able to do was find out answers to those things. We did it through litigation because we couldn't do it anywhere else. And so I don't understand the selective targeting. I don't understand if they want Mr. Powers to pony up $800,000 with a check or how they intend on doing that, and why I'm liable for time spent on the receivership, which they admitted today. The heavy lifting was done well before I came on, and I came on, reviewed the case, tried to get books and records, tried to get answers to the rent, even offered to drop all of the claims, like I said, except for asking for books and records, and they said no. So I've been trying to make deals. They didn't want to do it. They created work for themselves instead of being reasonable. And I anxiously await the court's opinion on not just fees, but on sanctions. It's unjust. I don't understand how opposing counsel could possibly say there was good faith consultation on this. It's untrue. And I will leave it at that.
Okay, thank you. Mr. Sheehan, I don't know that I need to hear from you. You're here. Is there anything that you have to say? You're muted.
I think I'm off. Thank you, Your Honor. No, my sole purpose for appearing today was to, frankly, assure the one question you asked of Ms. McCready, and she answered in the affirmative. I have, but given that we filed the response, and I just wanted to make sure that there was a question. We were here. I would actually ask to be excused from the hearing unless there's some additional participation required by me.
You may be excused.
Thank you.
Thank you. Okay, Ms. McCready.
Yes, let me just respond briefly to a couple of those points, Your Honor. And unfortunately, this is a lot of the same. apologize because this is something that you have been hearing for as long as we have, over 2 years at this point. There is a lack of appreciation for the corporate form here. And so when Mr. Powers is now representing that he attempted to make a deal, I'm not really sure what that deal was. But as we've been very clear with him throughout his involvement in this case, Asator is not a party to this case, has not been a party since the very first amendment of the complaint, before which it was only a nominal party. Asator is not the entity that I represent. I represent 4 individuals, 2 of whom are on Asator's board, 2 of whom are not. Those 2 individuals that are still on the board are not a majority of the board. They cannot do anything for this company. And so this is a point that we've been clarifying to him throughout his involvement in this case. It is part of what we very specifically go through in great detail in the Rule 11 letters that we sent, both of them. The first of which he also received. The second letter details what is incorrect in the 3rd amended complaint. It explained everything that was factually unsupported with documentation and many times with citations to the plaintiff's own testimony. So there's a lot of arguments that we just heard from Mr. Powers that are not in the papers before the court. There are also arguments that point to the record without a citation, so it's a little bit difficult to navigate those issues. As far as going through which firm is on the hook or not on the hook for what, much of that is within the court's discretion. And the point here was simply to give the court a bit of a roadmap for the most kind of problematic sections of and time periods of this case. If there are additional, determinations that need to be factually made, I think that's for a separate proceeding. But what we are seeking is an award of all of the fees, either as a statutory fee award or in the form of sanctions. I think those are the primary points that require follow-up. So if the court has any other questions, I'm happy to answer those.
I do not have any other questions. With that, I will take the matters under advisement and issue a written ruling in due course. Thank you all. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you, Your Honor.